Hi everyone, thank you so much for watching my videos. We're now going to look at topic 3, the rights of the authority. Now we already know that the authority, the Financial Sector Conduct Authority, FSCA, has the rights to suspend licenses and then subsequently withdraw licenses or issue administrative penalties against FSPs. But now we're going to look at the other rights that the authority has in terms of FSPs, in light of maintaining the integrity of the financial services industry. Now, one of the first rights that the authority has is to declare a certain practice as undesirable. Now, this practice that we're talking here about is not a lawyer's practice or doctor's practice. It's something everybody is doing, and it's not against the FACE Act. For example, nowadays we see that FSPs use electronic signatures, that is something that everybody is doing, general practice. Now, if the authority reviews a general practice and he feels that it's likely or has harmed relationships between FSPs and FSPs, or between FSPs and clients, or between FSPs and the public, or that this practice unreasonably prejudice, deceive, or unfairly affect any client, or if it continues, the objectives of the FACE Act is likely to be defeated, it will be declared as undesirable. What I want you to understand is that before the declaration of undesirable practice was made, the FSP that did this practice didn't do anything wrong. Okay, but once it has now been declared as undesirable and they continue with it, then they are doing something wrong. Now, the process that the authority must follow in order to declare a practice as undesirable is quite onerous. First of all, they must issue a notice of intent, and they must do this in the Government Gazette. This is the only time that we still publish in the Government Gazette. And then the FSPs have 21 days to make representations to tell the authority why they think this practice shouldn't be declared undesirable. Now, if the authority is not convinced, they will then make the practice undesirable by issuing an undesirable practice notice. This means that you cannot continue with this practice. FSPs must stop the practice immediately. If they do not stop the practice immediately, they can be liable for that maximum fine of 10 million and/or 10 years imprisonment. Also, unlimited cost orders can be issued on the FSP. And then the authority will also issue a notice to rectify any damage or loss that was caused to the client. So if you cause a damage or loss to a client because you continued with the undesirable practice, then you've got 60 days to rectify it, to pay back the client their money. Now, all that I taught you now about undesirable practice is actually obsolete, okay? Although you still get a lot of questions on it in the exam, so please know it. Because since 2014, the authority has now been given a superpower. They can issue a directive, a direct instruction to whom the FACE Act applies. So they can issue a directive to a representative, a key individual, a FSP, and a compliance officer. So this directive can be general, okay, so it can be to a specific sector or to the whole of the industry, or it can be limited to a specific person or specific FSP. Now you can see with the undesirable practice, it was quite an onerous process to stop something from happening, but now the authority can just issue a directive, tell you to stop it, and you must stop it. Now the directive takes effect on the date determined in the directive, and the authority must, if the directive is issued to ensure the protection of the public, then publish the directive on the official website by way of FACE notice. Now we're going to look at the rights of the authority in terms of business rescue and liquidation. Now the authority may apply for business rescue or liquidation of an FSP even if it's solvent. Okay. Now, liquidation is a situation that happens when a company is in financial distress. They can't pay back their debts. Then the company itself or the creditors applies to a court of law that the assets are sold and they are paid. Now, business rescue is something that's been introduced quite recently that is an alternative to liquidation. Now, business rescue is where the creditors feel, you know what, we're not getting paid, but the company can do okay. It's got sound fundamentals, but management sucks. And then they apply to a court of law so that management is removed and a business rescue practitioner is appointed. Now, with regards to liquidation, the commissioner can apply only after an on-site visit of liquidation of the FSP. Now, with liquidation, it's quite easy. Once the FSP is liquidated, it will stop operating and the license of the FSP will lapse or it will be withdrawn. But what with business rescue, especially if another party applied for business rescue of the FSP, because now you're going to have a business rescue practitioner that's placed in this business, and his only goal is going to be able to save the company. But who's going to look out for the rights of the client? That is why if another party applies for business rescue, all documents must be lodged with the authority before the application can be heard in a court of law. If the authority feels that this application is not in the best interest of clients, they can oppose the application. But if the application gets approved by the court, then the authority has the right to approve the practitioner. They must approve any action that the practitioner takes, and this is obviously to protect the client. Thank you so much for listening and have a wonderful day further, and I hope you are actually enjoying your studies.